Yeah, good morning, everyone. Many thanks, Max. Many thanks for the opportunity to speak at one of the opening sessions about electronic securities, brand new, so to say, here in Germany. And a special thank you for having 20 minutes only to cover such an, from my perspective, interesting topic. Now, I would like to use this time to give you a quick overview on the proposed German draft regulation of electronic securities, one of the most recent outcomes of the German blockchain strategy, which was adopted in mid-September last year already. In a second step, then my partner Steve in Luxembourg will share his views on the approach taken by the German legislator from a Lux and French perspective, and will probably be able to add his lessons learned. Now, what are we talking about? Early August this year, the draft regulation of electronic securities, which had admittedly leaked a couple of days before, was officially published. The draft provides for a completely new, so to say, legal framework for electronic securities, and in particular, the opening of German law to innovative technologies like DLT in order to modernize German securities laws. In its core, the draft proposes the introduction of an Electronic Securities Act, allowing for paperless electronic bearer bonds, and also introduces some consequential adjustments to other related laws, such as the German Banking Act. Now, the introduction of electronic securities is initially limited to electronic bearer debt instruments, and electronic shares, i.e. equity, and fund units will be included, or shall be hopefully included, in a second step. And the draft is worded in such a way that a later opening for those further types of bearer securities can be easily achieved. Now, the consultation of the current draft closed a couple of weeks ago in September. And to be open here, I have not seen any revised drafts yet. But as far as I know, it is still intended that the new regulation will be adopted by the German Parliament by end of this year. Now let's see what COVID-19 will help to this. Let us have a look at the core elements now of the draft. Now the draft opens the existing German securities law for a paperless electronic issuing form and clarifies basic characteristics of electronic securities. In doing so, the German legislator did not intend to create a new security of its own kind, sui generis, but simply to extend the available forms for bearer securities. And as a consequence, electronic securities are no different in legal nature from traditional securities in Germany. Now, an electronic security is issued by making an entry in an electronic securities register, instead of issuing a physical piece of paper, a certificate, which is currently required under the German Civil Code. It is simply created, as usual, one might say, by agreement between the issuer and the initial purchaser, the initial holder, in combination with this registration. A subcategory of electronic securities are crypto securities, which are registered in a crypto securities register. And we will speak about the register in a minute. Here, it's fair to say that the counterpart of such subcategory crypto securities is unfortunately missing in the current draft. A trick or little helper used by the German legislator to ensure that electronic securities fit in the current architecture of supervisory and civil laws around traditional bearer securities as smoothly as possible is that electronic securities are deemed to be a movable asset within the meaning of the German Civil Code, a Sache. And based on that fiction, investors in electronic securities will benefit from the same ownership protection as in the case of traditional securities issued in the form of certificates. Now, coming back to the register, the current draft provides for two different concepts of registers: a central electronic securities register and a decentralized crypto securities register. In any case, the registrar must ensure that any participants in the register can inspect the register electronically, and such concept of publicity is in fact an essential feature in the context of bearer securities, and it is the starting point of the acquisition in good faith, the holy grail of German property laws. And against this background, for instance, any disposal of electronic securities requires a registration or transfer in the register to be effective. So everything needs to be in the register. The central register of electronic securities, as you can guess, is a register in which electronic securities are registered and maintained by a central body. And according to the draft regulation, the registrar may only be an authorized central securities depository, CSD, which means from a German perspective, a licensed credit institution. In contrast to such central register, the draft also introduces a decentralized crypto securities register, which does not require an authorized CSD. In fact, the issuer can perform the function of a registrar either itself or leave it to a service provider. It is, however, important to be aware of that according to the draft, the keeping of a crypto securities register in Germany, even for your own electronic securities, constitutes licensable financial service within the meaning of the German Banking Act. Now, and this obviously creates a significant drawback from my perspective for startups. Before even issuing crypto securities and keeping in the register, the issuer would need to have obtained the relevant financial service license from BaFin, and as part of such process, evidenced an initial capital of at least 730,000 euros. I mean, from my perspective, a clear roadblocker, I would say, for someone just about to enter the market. In order to transfer ownership of an electronic security, the electronic security must be transferred to the purchaser on instruction of the beneficiary, and both parties must agree that the right is actually to be transferred. While any transfer and sort of keeping the register in mind requires that the previous holder is deregistered first, the draft regulation also aims to avoid any abandoned electronic securities, so with no owner, and explicitly states that the beneficiary does not lose its ownership until its successor is actually entered into the register. So you can really see the importance of the register and actually being in the register. In particular, in the context of the transfer of ownership, the draft regulation protects the trust of any purchaser acting in good faith in the seller's power to procure entry in the register, i.e. the seller's actual ability to effect a registration of the purchaser in the register. The purchaser, when acting in good faith, should be able to trust that the seller is the actual owner of the electronic security if the seller is actually registered in the register. In fact, it is in favor of the person who is registered in the register deemed that, for instance, the content of the register is complete and correct, or that the seller has the power of disposal, unless obviously the purchaser is aware of something different at the time of its registration, or is unaware but due to gross negligence. In this context, the purchaser does not need to have any sort of positive knowledge of the content of the register. However, if something different is shown in the register, such as, let's say, a restriction on disposal, the contents of the register are deemed to be known and destroy the good faith of the purchaser. Now, when you look at sort of these key features of electronic securities under the German concept and how they are transferred, you can clearly see that the German legislator has taken the conceptual approach to keep the existing robust framework of supervisory as well as civil laws around bearer securities, but unlike some other EU jurisdictions, still bases the rules for electronic securities on traditional in rem principles. I mean, bear that fiction in mind, which is used as little helper here. And that the German legislator has, in my view, for valid reasons, not introduced new securities sui generis. Now, Steve, I wonder which approach had been taken here, for instance, by the French legislator in its DLT regulation, or which approach is currently sort of discussed in Luxembourg, and whether we could benefit from any experiences made. Steve, could you sort of share your views on that?
Thank you, Gregor, and good morning. Good morning from Luxembourg. Yes, so my role here is to take you on a little virtual trip towards the west and look at Luxembourg and France. And we will see that obviously the same questions as Gregor has just mentioned in relation to the German initiative have also been dealt with in Luxembourg and France, with maybe the interesting element that in both jurisdictions there are laws on the books already now that deal with this question. So allow me first to look at Luxembourg, which is obviously my jurisdiction. What we see in Luxembourg is that there has been a law in March 2019, and there is currently a bill that is pending before Parliament that has been deposited in the summer within weeks of actually the bill that has been published by the German legislator. In Luxembourg, the measures that have been taken and that will be taken under the new proposed bill are, first of all, limited to securities. I think that's a difference to France. And we know we talk about securities token, but it's not unimportant to note that France has also a regime around non-securities token, particularly utility tokens, ICOs, under the Loi Pacte. So in Luxembourg, it's securities token or securities, digital securities only. And the important thing to note is that in Luxembourg, this reform, this modification has been embedded as well in the existing securities legislation. And in Luxembourg, the 2019 law has amended our law on the circulation of fungible securities, the 2001 law, which is basically the system that operates, the legal system that operates intermediated accounts, security systems in Luxembourg, CSDs in Luxembourg, and it's the legal basis for fungible book entry securities. And what the Luxembourg legislator has done is actually twofold. On the one hand, it has not changed the existing architecture. So it has not introduced new intermediaries. It has not introduced a new role or a new type of professional that would be operating these digital securities. What it has done is that it's created legal certainty around the use of distributed ledger technology. In the wider sense, it actually speaks of secured electronic registration systems, including distributed electronic databases or registers. So it's a much wider definition that is not intended to be limited, and therefore it tries to achieve a certain technology neutrality. And basically what it says is that accounts can be operated, securities accounts as they have existed for a long time, can be operated by these technologies, and at the same time registrations of transfer of securities, which is the way by which property rights in those securities are transferred by booking from account to account, have the same equivalent effect even if they are used under this technology. The second thing is the Luxembourg legislator has dealt with certain specific legal issues. One of them, quite interesting in this world, is the concept of fungibility. Now, there was a big discussion in Luxembourg about the difference between legal fungibility and technological fungibility. I mean, when we speak to sort of DLT specialists, they obviously frown at the concept of fungibility in the DLT environment, but we need that concept from the perspective of the securities legislation and fungible book entry securities. So the legislator has dealt with it and said that they will not lose their fungibility just because for technology reasons there may be a different solution. The second element, and again, this shows that Luxembourg obviously looks as an international financial center, has at at the front of its mind and its considerations the international cross-border aspect. Now we know the cross-border issues around the use of DLT. Where are the securities actually located? Are they located anywhere because the distributed nature of the ledger? So again, the Luxembourg legislator has created a rule that makes sure that there is a location, and it basically has extended the sort of prima approach, which we know again from the classic example is, which it was sort of the good solution to do, because obviously we're keeping the basic architecture of who's holding those accounts as licensed entities that are holding those accounts. The 2020 law is going to introduce, if it is passed in the way it is proposed, a similar recognition for another law, which is the law on dematerialized securities. And this will contain the element not of circulation of security, but issuance of digital securities by using this technology, by allowing the issuance account, which is the golden truth, obviously, in the dematerialized system, to be held in the form operated by using DLT technology. Now, again, the basic architecture is not changed. There are still licensed intermediaries that intervene to operate this, but still the technology is really recognized in order to give legal certainty. Now, a quick look at France. Again, we talked about the law Pacte, so I won't insist on this. That's really a regime for utility tokens mostly, or other forms of token, non-securities tokens, which are recognized, and there's a legal framework for ICOs and service providers. On the securities, digital securities, we see the same approach, except that the result is different because the French starting point was a different one. The French legislation particularly only applies to unlisted securities, and it applies to securities which are not admitted to operations of a CSD. So the French legislator wanted to stay away from this issue and the interaction of the European provisions and its national regime. But it has not created either a self-standing regime, and it is also based on the recognition of equivalent effects of the operations that happen on the register, on the one hand, in the normal world, and in a distributed ledger system in the other world. So, and time is obviously too short to go into the details, but I think what we see, to conclude on this point, is that the regimes are currently striving at achieving the same thing, which is embedding these sort of new forms of securities into existing legislation, but they achieve not a harmonization. So it remains a fragmented world, but it's a fragmented world which is largely due to the fact that the national securities laws are already very different today. Now, the interesting question is the EU Commission going to do something about this? Now, we have seen the regulation that Gregor and my colleague Rado are going to talk about this afternoon, the regulation proposals that have been made, which do not seek to do that. And interestingly, yesterday, a webinar was organized by the European Commission, where one of the officials said that they do recognize that this is a Herculean task, and it's probably not the right thing for them to do. But they said, we do realize that convergence is important for the market in order to achieve some kind of a cross-border marketplace. And what they said is that they might think about publishing an interpretive communication at some time. So let's see what happens there. The interesting element, and before I hand back to Gregor, is that in the AMF memo, the AMF, the French regulators, published a memo in 2020, where it does open, at the very end of the memo, the door to say, well, we could, in the medium term, consider whether we can create a new form of bearer security, which represents this digital security represented in the ledger, which for France would be a real important change. So I think that's something that is discussed in Germany as well, maybe in the reverse. Gregor, back to you.
Yeah, many thanks, Steve. That's quite interesting. And from a German perspective, it's good to hear that even in an international context, the German draft seems to be quite advanced and sort of well thought through, at least from my perspective. Now, and I'd like to come to an end. Now, my overall conclusion, I mean, it's not easy to say, but I'd like to sort of slightly rephrase Neil Armstrong, not Lance Armstrong. And I would say that the draft is one small step for the crypto community, one giant leap for traditional capital market lawyers. So from our perspective, from our legal traditional capital markets lawyer perspective, it's a huge effort which has been achieved so far. But it's also fair to say that some aspects of the proposed regulation In particular, for instance, the requirement of a financial service license, even if an issuer of crypto securities keeps the register by itself for its own securities, seems to be, like to be fair, some other aspects disproportionate, and in my view create a clear roadblocker for startups, or sort of just someone who's about to enter this new market. Now I'm coming to an end now. If you wish to share your thoughts on the draft regulation with us, please feel free to get in touch with us. It was fun, and back to you, Benjamin. Thank you.